I think I have to go ahead to start now. Okay. Good afternoon, everybody. Welcome to another session. And I have the distinguished honor of introducing the speaker for today. No other person than Ms. Stella Duru. Ms. Stella Duru is a senior lawyer and well-revered legal practitioner within the Nigerian energy and corporate commercial space. She's a partner in Banwa Nigodalu in the Energy and Natural Resources Practice Group. She obtained her law degree from the University of Lagos and was called to the Nigerian bar in January 2001. She joined BNI shortly afterwards and was admitted into the firm's partnership in 2012. She's a consummate professional with excellent mastery of the entire value chain of energy projects and 20 years of cognate experience advising on mergers and acquisitions and corporate and commercial transactions, including oil and gas, power and infrastructure within the energy sector. She's ranked by various national and international directories as a leading lawyer in the energy practice area. She has deep experience in oil and gas and power projects in Nigeria, and has indeed been involved in World Bank-sponsored work streams, advising on the power sector reforms in Nigeria. She leads the team advising a group of investors in a notable free trade zone in Nigeria in connection with the establishment of a 40,000 barrel per day hydro-skimming plant and refinery. Similarly, she leads the team advising a gas utilization company in connection with the conceptualization, structuring, construction, and operation of a gas processing plant. So the more interesting things about Ms. Duru, she was recognized by Business Day among the top 20 outstanding women in business law in Nigeria. And she's an associate of the Nigerian Leadership Initiative, a leadership development not-for-profit, and it's affiliated with the Aspen Institute. She's also an associate of WIMBIZ, an association of women in management, business, and public service. She's a non-executive director of the board of Zcrest Capital Group, which is a capital management firm. She's also a non-executive director on the boards of Zimvest Limited and Rexel Pay, both subsidiaries of Zcrest Capital. She was recently appointed a member of the Council of the Section of Business Law of the Nigerian Bar Association, and also the vice chairman of the Conference Planning Committee of the 15th Annual International Business Conference of the MBA section of Business Law. All I have said does not do justice to the kind of individual that is going to speak to us. She's well revered, like I said, and she's respected by peers, juniors, and she's a mentor to many. And I'm sure that we're going to have a very enlightening and wonderful conversation and session with her. So I'll hand over to Ms. Duru now to take over.
Thank you so much. At some point, I was wondering who it was you were talking about. But first things first, good afternoon to everyone that has found time to join my class, because I'll be telling everybody I'm going to be teaching a class today. So I thank you for finding the time to join this class. And I hope that at the end of the class, I would have impacted some knowledge based on the topic that I was charged with. So anything you hear, just know that some of the faculty just imposed the topic on me. And I decided to, try and do justice to it. So our topic for today, like my slides show, it's on asset acquisition and development. I'm not sure if the time that has been allocated is enough to do justice to this, but basically I'll be touching on the structuring of assets acquisition deals, the documentation that you typically would see in such deals. And if there's enough time, I would touch on asset developments, which is totally different from, when you're acquiring an asset. So moving on really quickly. Okay, so now my slides are not paying attention to me. Let's see. Okay. So today I'm basically just going to go through what I'll term the definition and classification of assets, the typical stages you would see in an asset deal, key structuring considerations that any lawyer or advisor on an acquisition deal should pay attention to, tips on due diligence. I'm sure some of my colleagues that have taken the earlier classes may have touched on this, but I would bring my own spin to it. The typical agreements and documents that you see in an asset acquisition deal, the usual regulatory consent and approvals that you must necessarily assure are gotten for the deal, if not the deal will be stalled. The key documents that you see in an asset development transaction, and then the financing of the acquisition and or the development of any of the oil and gas assets. So from this picture, you basically would see what we term as the three broad areas in any oil and gas, in the oil and gas sector. So you've got the upstream, you've got the midstream, and you've got the downstream. And typically, when you're speaking about acquisitions, what you would most likely be, buying, if you're looking at the upstream space, would be the oil mining lease, or in some cases where you're waiting for the oil prospecting license to be converted to the oil mining lease, there could be the opportunity to actually acquire that. And that is what you typically would see. In the midstream, you're looking at facilities and infrastructure. And usually you would also be looking at licenses like the oil pipeline license. And for the downstream, you'll be looking at gas processing facilities or refineries, filling stations or LPG plants. These are the typical assets that you would see that people are looking to sell or divest interest in. So I'm not going to, I know that the very first class taken by my partner had gone into the different areas of the oil and gas sector. So I'm not going to delve into that. So going quickly into the typical steps you would see in an asset acquisition deal. The question would be, what should be the first thing when you are conceptualizing an asset acquisition transaction? And most people, well, the jury is still out there, whether you should be signing an NDA first or you should be structuring the transaction first. But then depending on how you look at it, and most M&A transaction advisors, you hear them say things, the typical buzzwords, the sell side, the buy side. So the entity that is seeking to sell the assets would be the sell side, and the entity that is looking to buy will be the buy side. Now, management can decide that they're looking to raise money. More often than not, what are the considerations for why you want to sell something? You're looking to raise additional financing for maybe ongoing operations, or just basically you want to divest of this particular asset, and you probably want to put more money in the pockets of the investors that took the risk at the beginning. So at the point where the non-disclosure or confidentiality agreements are discussed, it could be in different phases. It could be at the point where you're seeking to get advisors on board. So the management of the sell company, the entity looking to sell, could decide at the management level and the board level that, okay, we're seeking to sell either shares or some of our assets, and I will delve into that as I go along. And then at the point where they've gotten the board or the management approval to proceed, advisors are necessarily brought into the room. Because of the nature of the assets that are being spoken about and how people typically would guard their trade secrets, you won't want to have conversations, or you won't want it to be out there in the market that you're about to sell something unless and until you have gotten the relevant parties to sign what we call the non-disclosure agreement or a confidentiality agreement, which simply is just an agreement that binds the parties that are going to be getting the information on the company that's seeking to sell, setting proprietary information that should not be out there. So you typically would get the relevant parties to sign this document and hold them to some confidentiality until such time that you're ready to communicate to the entire market that you're looking to divest or sell a particular part of your business or some of your assets. Now, with certain people, the point could be made that, but management could agree what the structure should be before you actually get parties to start signing the confidentiality agreement. Management could actually start at the conceptualization stage to decide that they want to go the way of a share sale deal. But as parties start to talk and advisors start to advise, depending on what the balance sheet is saying or what liabilities exist at the point where you're seeking to sell, you could actually now then decide not to go the way of a share sale and go the way of an asset sale. So based on what I've shown, stage 1, stage 2, interchangeable, it's dependent on each particular company and how they want to go ahead with this. Now, before you go into negotiating and drafting the relevant key primary transaction documents, you necessarily need to diligence the assets to be acquired, to be sold. And I'll be using the word divest, acquired, sold, bought, interchangeably. And as an advisor, you have to be very clear in your mind who you're protecting. And your client would either be on the sell side or be on the buy side. And depending on where you're sitting, there are certain things that you necessarily must do during the due diligence phase. I will speak to that as we go along. Then the next phase will be drafting and negotiating transaction documents. I will be looking at the critical clauses in the key documents that underpin acquisition deals, which would be your share sale and purchase agreement or your asset purchase agreement. And then, of course, that agreement typically would list out what we call conditions precedent, which are conditions that necessarily must be fulfilled before monies move. Financial close is when monies move, and then there are post-completion obligations. So I had touched on the NDA. Like I said, it's basically an agreement that helps you to protect sensitive and proprietary information. And you usually will have that in place to ensure that parties, do not come to the market before you are ready to let the market know you're about to do this deal. You will define the nature of the information that you deem to be confidential. And you could actually, in the phasing of your asset acquisition deal, determine what information to be given at every stage of the transaction. So you could actually have a situation where you could sign several confidentiality agreements based on the nature of information that you are actually disclosing at every point in time. And it also specifies the liabilities where the receiving party has now then disclosed information that ought not to have been disclosed. I'm sure most of us know what the typical provisions in an NDA would be like or should look like. But for the most part, you must be clear in your mind as to the term of the NDA and the fact that you want whoever is holding this information, which is proprietary to you and is sensitive and is part of your trade secret, that they could hold it for a specific time within which, if they disclose that information, it could impact the total valuation of the deal that you're trying to put together. Now, the question is, when you're structuring an acquisition, which should you do? Should you structure it as a share deal or should you structure it as an asset deal? And there are different considerations in determining how you want to go. First things first, what is the nature of the asset to be sold? Are you just thinking of selling the shares of an existing business? or are you looking to sell not the shares, which would entitle anyone that buys it to the, to interest in all of the assets that that company holds at the point in time? Or do you just want to ring fence part of the assets that you have within your operations, that you just want to sell that for the purposes of raising money? Now, there are different considerations at every point in time. Also, the risk appetite of the project sponsors and the kind of sponsors that are involved here. When I'm speaking of sponsors, I'm speaking of the seller. So where it's a private company that is selling, there are separate considerations. When it's a government entity that is selling, of course, there are also certain key legal considerations. And I think at this point it's important to make it clear that when you are the lawyer for a government entity that is seeking to divest its interest in an asset, one key thing or one key legislation that must be at the back of your mind is the, I believe it's the Public Procurement Act, which has specific provisions on how government must divest of its interest in any asset that it holds. And then, of course, you need to get the no objection from the Bureau of Public Procurement, which is the agency that oversees competitive bidding and divestments by government entities. So necessarily, you need to pay attention to that. And that, of course, touches on the nature of the project sponsors. Something else that is important, especially for when we're talking of government agencies within the sector that we all play in, is the World Bank negative pledge. So for most government entities that have taken loans from the World Bank, there are very stringent rules and provisions that underpin the loans that have been extended. So you can't do certain transactions, you can't create security over your assets without getting the consent from the World Bank. And the process for going through all of that can be extremely tedious. So typically you will find ways around those in determining, should we go the way of a share deal, an asset deal, or should we structure it in another totally different way that, and that is the difference between a normal, run-of-the-mill lawyer and one that is very commercial in their outlook. The type of security that you'll be creating will determine whether you want to go the way of a share deal or the way of an asset deal. More often than not, most people prefer to go the way of the share deal because it is deemed to be relatively simpler. The timing for concluding a share deal is deemed to be shorter. The transfer of liabilities related to the business, well, depending on how you look at it, you could diligence a company and be able to identify some of the liabilities today, but then there are certain contingent liabilities that may never crystallize until years from when you've closed the deal, and you may not be immediately able to identify those contingent liabilities. So those could be one of the cons of going the way of a share deal. On the asset deal side, even though it appears to be a bit more protracted, sometimes it is best to go that way because you are ring fencing that asset from any liabilities that sit with the company. And you're just basically saying, okay, I've seen the balance sheet of this company. If I buy the shares of the company, I would be carrying on certain liabilities that I'm not ready to deal with right now. So why don't you just, I'm looking at the producing asset and I'm determining in my mind that I don't want to deal with your historical liabilities. I just like this asset that is, remains viable and it is producing. And that's the asset I want to, acquire. But then there are also certain considerations with that because the diligencing of any asset is more protracted. You're looking at, take for instance, and let's drill down a bit. If you're acquiring a company that holds an OML, and you say, oh, I'm not really interested in the shares. I am really and truly, I don't know how you can buy, an OML separate from actually acquiring the shares. But anything, we can structure things based, provided that it's within, the ambit of the law. But with an OML acquisition, for instance, you necessarily need to carry out certain checks at the lands registry in relation to the area where the OML covers. You'll be required to do certain other specific regulatory checks, which could be, could take a longer time than if you were just doing a simple share deal. It could also be argued that while share deals appear simpler, there are also certain things that could affect its ability to be the preferred option. And I will, touch on that as I go further down during the class. Sorry about that. So, like I tried to speak to, there are certain pros and cons for share deals. You'll be required to carry out extensive due diligence on not just the company, but all of its assets. Because when you're acquiring the shares of a company, you necessarily would be acquiring all of the assets as well. When I get to the section that deals with due diligence, we'll look at the specific things that you necessarily must be checking to be able to determine whether you want to go one way or the other. With asset deals, only specific assets, like I said, are acquired. You're not acquiring the entire assets of the company. And then they're relatively more complex because there are specific material contracts that you necessarily need to now then enter into deeds of novation or deeds of adherence and basically be bound to those agreements that have been entered into prior to the acquisition of the assets. And there are consent requirements or obligations under those existing contracts that necessarily need to be procured from counterparties that are in those existing material contracts. So like I rightly stated, that there are different considerations in determining one way or the other which option you should be advising your client to take. One important point that I think we need to pay attention to would be how you would structure the shareholding of the acquisition vehicle. Now, for most entities or most people that are looking to acquire assets in the oil and gas sector, it's important to note that an individual, Stella Duru, as Stella Duru, cannot hold assets in the oil and gas sector. I necessarily need to set up a company for the purposes of acquiring interest in the assets that I'm looking at. So in structuring the acquisition vehicle, it's very important that you are very mindful of setting provisions that are very important that you must pay attention to when you're structuring the shareholding. One key provision would be looking at what the Nigerian Oil and Gas Industry Content Development Act of 2010 provides as it relates to, or how it categorizes Nigerian companies. Now, whilst it does not prohibit the award of contracts to companies that do not qualify as Nigerian companies, it gives the threshold of who it's deemed to be a Nigerian company. And it necessarily needs to be one that has 51% of the equity shares held by Nigerians. So if you're structuring the special purpose vehicle that you'd use for the purposes of acquiring this asset that is on offer, you must pay attention to the shareholding structure. More often than not, given how capital intensive these assets are and the fact that you need a lot of money, a lot of financing to be able to acquire these assets, it's important when structuring that you do not now then run foul of this 51% shareholding threshold, because that's important to ensure that you get a chance when you're bidding for contracts per what the Nigerian Content Act requires. before I just go into the due diligence phase of the class, I think one other important consideration is when you're structuring the shareholding for the special purpose vehicle that you'd be using for the acquisition purposes would be the issue around tax. And under the Petroleum Profits Tax Act, I believe it's section 21, there is a concessionary rate of 65.75% that is applicable to any oil and gas company within the first 5 years of its being incorporated. Now, ordinarily for everybody else is 85%. So when you look at that consideration and the savings you'll be making in the first 5 years, of course, necessarily you would want to go the way of setting up a totally new company that has not been in existence to actually be the acquisition vehicle for the purposes of your deal. So when you structure it that way, you're already making tax savings for the company, and that in itself is a benefit ultimately for the deal. Now, apart from how important structuring the deal is, and that's where, advisors must be very clear in helping their clients get to the finished line. The point is that with any asset that you're looking to acquire, there could always be issues, and you can't just come and say, oh, I've just been engaged, my client wants to buy this, and then you go straight to drafting documents. No, they've identified the asset that wants to be bought. That's if you're acting on the buy side. An asset has been identified that wants to be bought. Before you get to the point of negotiating the key transaction documents, you must advise your client that the assets must be diligenced. So you must undertake due diligence. Now, if you're acting for the seller, because you know you're going to get to a point where you would have third parties looking through the books of your company or looking at the documents that underpin the asset that you're seeking to sell, you necessarily must do what you call the vendor due diligence, which basically is where the entity that is on the sell side gets its own advisors to look through everything that it has and be sure that everything is fine, because you're going to have advisors on the buy side conduct due diligence on the asset and on the or the company for the purposes of giving the go-ahead to the clients to proceed with the transaction. So the due diligence phase is a very important phase of any acquisition transaction, and we cannot overemphasize the need to be very, very particular and very hands-on in identifying issues that should or could be detrimental to your client one way or the other. Now, looking through this slide, these are the typical key issues that you would be expected to look at or identify when you are conducting a due diligence audit on a company, if it's a share deal. And when you're doing, for a share deal, you necessarily would be looking not just at the shares of the company and who holds the shares that are on offer, but you'd be looking at all of the assets that sit in that company. So you'll be looking at the validity of the title to the assets. And in this regard, let's take the OML, for instance. You necessarily need to go to the Department of Petroleum Resources to confirm that that OML is still valid. And even if it's valid and it's going to be expiring the next year, your due diligence report must identify that. And that must be something that must be discussed with the sell side to determine what do you want to do now. The main asset of this company that you say you want to sell the shares, for instance, is the OML. The OML is going to expire in a year. Whilst we recognize that you have so many assets and you've been walking the field for this number of years, the document, the authorization under which you can continue operations only has 1 year left. What are the steps being taken to renew? And is there anything that could impact the renewal of the OML? You would also be expected to carry out searches at the land registry in the states where the land over which the OML covers, where it sits. And that is something that you have to pay particular attention to, because you could have the license, the lease, but then the C of O or the deed of assignment covering the land may be expiring. Those are all issues that you must necessarily be able to identify and tee up for the purposes of your client. You also need to identify the different permits and licenses that are relevant for the ongoing operations of that business. We know that the sector where we play in is one that has so many rules, regulations. You must be on top of all those rules and regulations and be sure that all the material permits, all the material consents, all the licenses, approvals that should be in place are in place. And any that are not in place, you must immediately identify in what we call your red flag report. So when you are engaged as a lawyer to undertake a due diligence, you're expected to, the very first step would be for you to prepare what we call a checklist. And the checklist will basically identify all of the documentation that you would like to see, to review, to be able to determine whether this is a good deal to proceed with or not. And what your client is expecting after they provided you with the relevant documents, which could be physical copies or could be by virtue of a virtual data room that's been put together, would be for you to immediately identify issues or gaps that could impact the conclusion of the deal. And the document that you use to do that is what we call the red flag report. So basically, you are raising all the red flags that should be looked at. They're setting issues that are things that could easily be fixed. There's some that are major that go to the heart of the deal and the purposes of, when you see stuff like that, you take a decision whether you are going to proceed with this or not. Usually, they are setting commercial decisions, even if they're legal problems that could fix such legal issues that have been identified by from your audits. You'd also be expected to look at material contracts entered into by this entity with other third parties. And more often than not, those material contracts could have certain waiver or third-party consents that are necessary before you can enter into a transaction such as the acquisition transaction that is being contemplated. In this respect, you have to identify those material contracts and make it clear to the client that we need to get this consent from this other party. If not, we cannot proceed with this deal. Given where we are, oil and gas operations, there usually could be environmental issues. So there are issues around spillages and if the right things have been done as it relates to the environment. You also need to identify those. You'll need to identify tax liabilities, community issues, how friendly are the communities that surround where the operational company or the operations are going on. Are these communities such that could stall operations? Have they stalled operations at any point in time? And if they stalled operations, how were these issues dealt with? You'd also be asking for a list of litigation, ongoing litigation, or even if there's no litigation that has crystallized, are there any claims that could crystallize in the future that could form part of the contingent liabilities that must be paid attention to? Of course, if we're dealing with the upstream side of things, a major agreement in that space is the joint operating agreement, and there are certain provisions in there that would basically state that before you can sell your participatory interest, there are certain obligations that must be met. And necessarily, whoever is, taking on those assets, whoever is acquiring the participating interest must be one that has the financial capability to step into your shoes, and if you are the operator, the technical capabilities as well to walk the field. And then, of course, one important part would be also the corporate standing of the target. So, and this is very important when you're looking at a share deal. A company or shareholders that are looking to sell their shares in a company, you need first and foremost to be certain by conducting searches at the Corporate Affairs Commission that that entity exists and that all the relevant returns that ought to have been filed at the CAC are up to date. Necessarily, you need to confirm that the person seeking to sell their shares are the real owners of the shares. So you necessarily, apart from doing the checks at the CAC, you'll be expected to check the books of the company, the corporate books of the company, which would include the share register, to confirm that indeed the parties that have represented that they own the shares that are to be sold indeed own those shares. So yes, I've touched on this as I was speaking through the issues. So, and then maybe to just touch on this litigation part a bit. A few of us are very comfortable and familiar with the corporate side of things, but we are not, we may not be as conversant with the litigation part of things. Now, when you are engaged to conduct due diligence, you must necessarily, put together a team of lawyers in your firm that have the competence to be able to actually do the audit that has been requested of you. And so the charge would be, don't say, oh, we learned criminal law and civil procedure in law school, and so because of that, I should be able to look at a court process and determine if a contingent liability is going to arise or not. You need to get to the experts, and they should be able to look at this documents and then decide for themselves whether indeed, these are spurious claims or they have any merit. I touched on the corporate standing of the target, material obligations in relation to the asset, and then moving on quickly, we are now going to be going into your typical documents and agreements. So the key documents that you will find in an acquisition deal would be the share purchase, the share sale and purchase agreement, and the asset purchase agreement. And you usually would, only start drafting these key documents, key agreements, after you have concluded your due diligence. And as we go through the critical clauses in an SPA or an APA, you would see why diligencing the asset of the company whose shares are on offer is very important. So the very first key clause that you would be looking at, or you should be paying attention to and be in a position to negotiate very fiercely, would be around existing liabilities and limits. So there are certain liabilities that necessarily you would have identified at the point where you're doing the due diligence. And you need to be able to understand how to best allocate the risks that arise from such liabilities. And you would be doing that in your SPA or APA. So, and at this point, you would also be expected as the lawyer holding the pen to understand the commercial side of the transaction. So you necessarily have to have, be part of the full meeting of all the advisors and be able to understand and appreciate the commercial aspects of the deal. For every, and when I say the commercial aspects of the deal, if you're seeking to buy an asset, the commercial and the financial advisors on the deal would have worked the numbers. and determine what the best price should be that you should be offering for this asset. That's if you are acting as a lawyer on the buy side. Now, after you have conducted the due diligence, there are certain liabilities that could, in actual fact, erode the value or the value of the assets, which you ordinarily would not have identified if you had not done the due diligence. So at the point where some of these liabilities are teed up, the initial price that was, agreed as the price to be put forward could then be reduced by virtue of some of these liabilities. And you're saying, okay, the value that we had at first, allocated to this asset was X. But after the due diligence, we see that there's so many issues and you haven't really, on the sell side, identified how you're going to take care of these issues. You are the owner of this asset. You've been working this asset for this number of years. You are best suited to, mitigate these risks. So we're going to leave some of those liabilities with you. Some of the ones that we see that we can't immediately deal with, we would, take a portion of the price that we ordinarily would have given you to take care of those liabilities one way or the other. So what are you doing by structuring this, the negotiation of this clause? You're allocating the risk where it should sit and with the party that is best suited to carry the risk. And as the entity that is looking to come on board, you're also trying to limit your exposure. We will talk about financiers and lenders, and where you're getting third-party financing, they're setting financiers that don't want to touch anything that's got major liabilities, no matter how you want to spin it. So necessarily, you would be using your SPA or your APA to allocate these risks in the right manner to ensure that the deal in itself remains bankable and one that the financiers would be happy to, stand behind. Of course, I touched on the issue of the price. Existing liabilities limits will determine what price you're putting forward. And of course, at the risk of repeating myself, if you as the lawyer drafting do not understand or appreciate the commercial side of things, you won't be able to draft the right clauses in this very key document. Now, another set of clauses that are very key. Most people, you've heard people talk about reps and warranties, representations and warranties. And yeah, we've been taught in school, and it's when you come into practice that you now then start seeing how it actually works. So the company that has come to you to say that it has this asset to sell, it's representing certain things to you. It's representing, one, that it has title to the asset it's seeking to sell, whether it's the asset as in facilities or the shares on offer. It's also saying to you that it has the capacity to enter into the transaction. What do you mean by capacity to enter into the transaction? That, one, the entity that is seeking to sell, that has represented that it has title to the asset, actually exists. It has been incorporated validly under Nigerian law. Two, that the board and the shareholders in that company have signed on that they want to do this transaction. So when I go further down and we're looking at some of the regulatory things on approvals that must be in place, you would see that some of the things that are very key would be, shareholder resolutions, board resolutions, basically approving that this transaction be done. Compliance with all relevant laws and obligations, including anti-bribery and anti-corruption laws. We are the lawyers. We must understand and have at the tips of our fingers, and even if we don't have it at the tips of our finger, we should be able to, research and confirm that the transaction as structured is one that would not run foul of any laws that are in existence at the time the transaction is being done. So everything, every single part of your acquisition transaction must be in compliance with extant laws and regulations. what I touched when I was talking about due diligence, I touched on the issue of litigation. Nobody wants to touch a company that is rife with litigation or disputes. All the money from operations is being used to settle one issue or the other. That means management and the board are doing something wrong. So absence of litigation is one of the things that the seller will be warranting, that we don't have any litigation. And even if we have litigation, we've looked at it, there's no contingent liability that can come out of it. We're warranting to you that we're clean. There's accuracy of information, depending on how or who you are acting for. If you're acting for the seller, they're setting information that will be required. They're setting information that will be required from you that you may not have a full picture of at the time that you're transacting. So there are different tricks, different drafting tricks that could be put in there to say, we are warranting or we are representing that the information we have provided to you is accurate to the best of our knowledge. So you should only be able to give certain representations and warrant certain information that you have 100% certainty around. Where you are not certain of certain things, you should try and take care of that by the drafting style or drafting language that you put in there to try and mitigate any liability that could arise from you extending this representation or warranting that information is accurate. Of course, necessarily you must comply with tax, environmental, health, and safety obligations. The oil and gas sector is one where health, safety, and the environment are very key and important to the success of your operations, especially where you're looking to expand your business or you're looking to get third-party financing, especially from the international space. These are key considerations that any financier will be looking to get warranties from the entity that is selling. On the buyer side, same thing, you have the corporate power and authority to actually buy this asset. You have confirmed that you also have all the consents and approvals. So let's touch on this a bit. You are an entity that has never held interest in any oil and gas assets. And this asset is now available. You've set up the special purpose vehicle for the purposes of acquiring the asset, but you've only just gotten registered at the CAC. You haven't gotten registered at the DPR. They're setting approvals that underpin the operations and the existence of companies that operate in the oil and gas space. So all of those approvals must necessarily be in place because whilst you're doing the checks on the sell side too is checking the buy side that you indeed have gotten the right approvals to proceed with this deal. When I go into the regulatory approvals, I will also speak to some of those specific approvals that must necessarily be gotten before the deal can be deemed to have been consummated. Of course, very key to any sell side is the financial capability of the buy side to actually put the money on the table. So you necessarily need to show where the money is coming from and that indeed you have the money. I emphasize the issue of corruption and anti-bribery and the issues that could come from those. And when you have extended these representations and warranties, you must be able to stand behind them because there are major implications for the breach of these warranties and major damages that will be expected to be extended where any of the representations are false or inaccurate. Okay, so in determining how you want to pay purchase price, it could be the way of a bank guarantee, and usually it's structured in such a way that you pay a deposit and then following the satisfaction of certain conditions precedent, then the balance can be paid. Setting, like I had mentioned earlier, these assets are usually very expensive. So to raise the money for these assets, the monies are usually a lot. Sometimes whilst the buy side is looking to put monies together, they could actually ask that, okay, hold on to a guarantee. And you can call on the guarantee if on day X, I fail to pay the balance, or, I'm not able to raise the balance, and, matters around that. Or you could get a firm commitment from the lenders to say, a deposit has been paid, we'll pay the balance at completion once all the conditions precedents have been satisfied or waived. Dispute resolution and governing law, I don't think I need to touch on that too much, but it's important to pay attention to this, because there are certain financiers that would prefer for the governing law of your share, sale, and purchase agreement to be one that is not Nigerian law. For there are certain considerations, there are different reasons why they would want that. They are more comfortable with the laws of England, for instance, and necessarily you need to understand the difference between, especially where now there is the basic principle that the law that should govern the agreement will be subject to where the agreement is going to be performed, where the asset sits, and all of that. And usually most people would, stand on those principles to push for Nigerian law to be the law, the governing law of the agreement. Now, depending on who sits behind the special purpose vehicle that is seeking to acquire this asset, there could be the demand for the laws of England to be the governing law. Laws of England, Nigerian law is derived from laws of England. So more often than not, you could agree to that. But where you now start getting people asking and that you have maybe the laws of Texas to be the governing law. As the Nigerian lawyer on this side, you may be a bit hesitant about that because you may not be familiar with the specifics of the laws of Texas, and that in itself could impact the entire transaction if the matter goes, if any provision in the agreement goes to dispute. So that's a provision that should be negotiated very carefully and to understand the ramifications that could come from agreeing to a governing law that is not one that you're familiar with. Of course, whether you want it to be a matter that goes to court or one that should be subject to arbitration is also a key consideration when you're putting your SPA or your APA together. And of course, in this regard, you'll be looking at differentiating the seat of arbitration from the governing law, because the rules around discovery and all of those differ from jurisdiction to jurisdiction. So you need to be very clear in your mind as to how to structure those clauses, the drafting of those clauses as well. Now, for conditions precedents, these basically are setting conditions. So you've undertaken the due diligence. You've identified there are setting gaps. Like I had said earlier on, there are setting gaps that can be fixed by the company in question, the sell side, taking certain steps and cleaning up certain things. You haven't filed your annual returns at the CAC. We can do that. When do you think you can do that? When do you think you'll be able to do that? We should be able to do that within a month of signing the document. Okay, you put it down as after we've signed the relevant agreement, either the APA or the SPA, sell side is supposed to get annual returns and certain other things in place within 1 month. So you would have a long laundry list of issues that would give the buy side comfort to conclude the transaction. And there are certain things that the buy side could take the call on, and just look at it and say, well, I don't think this should impact my ability to close the deal. And they would be in their right to waive it, because you'd have language in the contract that will basically say these conditions should be satisfied or waived by the party that has the right to waive the satisfaction of same. And your typical conditions precedent could be getting the relevant board and shareholder resolution. So I had mentioned that you need to get certain resolutions. If at the point where due diligence has been done and parties have started negotiating and are almost closing out the negotiation of the relevant agreement, the relevant resolutions have not been, gotten, it could be one of the key conditions to actually closing the transaction. There could also be the obtaining of waiver of preemption rights under certain material contracts, which, in this regard could also include the JOA. There could be the issue around when the balance of the consideration should be paid, and also getting the minister's consent or DPR's approval for the transaction. And in something that's become important to us in the sector would also getting the FCCPA's approval for a transaction of this nature. Post-completion in this regard, where it is an asset deal, you'll be expected to, enter into a deed of adherence to the subsisting joint operating agreement. Now, where it's a share deal and it's 100% of the shares that is being acquired, you may not be required to enter into any deed of adherence to an existing shareholders agreement, for instance, because you're buying out everybody. But where for instance, the deal is such that you're just going to be one shareholder coming on board, buying out one of several shareholders, you necessarily need to pay attention to the subsisting shareholders agreement if there's one that is in existence, and because you'll be expected to enter into a deed of adherence, which basically just means that you're going to adhere to all of the obligations and the provisions of the relevant shareholders agreement. For the share sale, corporate authorizations, same thing, payment of balance, minister's consent, approval of the Federal Competition and Consumer Protection Commission. That's the FCCPC, yes. And then of course here, in this regard, issuance of new share certificates, because the old certificates will necessarily be withdrawn from the shareholder that is selling and destroyed, and new share certificates would be issued to the new holder of the shares, and necessarily, very important, the name of the purchaser must be put in the register of members, because CAMA is very clear that the prima facie evidence of title to any shares would be seen by annotations in the register of members. Okay, so regulatory approvals. I had now time check. Okay, it appears I may not be able to go through all the slides. Okay, so regulatory approvals. I had touched on this when I was speaking earlier on about setting approvals and consents that you must get. Now, for every acquisition that is happening in the upstream and even in the downstream, there are certain consents that the Petroleum Act has mandated must be gotten. Very clearly, before you assign any license or lease or any right, power, or interest in any license or lease, you must get the consent of the minister. And the consent guidelines issued by the DPR actually extended interest in a pipeline license or an OML to include any arrangement whatsoever. And we're talking production sharing contract, production sharing arrangements, farming, farm out agreement, sale, purchase, anything, that would result in any arrangement by which any right, privilege, power, advantage in a license or a lease would be transferred to a third party, directly or indirectly. You necessarily must get the minister's consent. Of course, anyone that is following the trend or conversations in the space would know that, when these guidelines came out, there was the issue of, are you saying even if I'm selling one share, I must go to the minister for consent? And what if the transaction is happening outside of Nigeria, or it's happening indirectly? So it's not the transaction itself is not happening in the company, within the company of the, sorry, it's not happening within the company that holds the OML, but it's happening maybe in the company that holds shares in the company that holds the OML. So that's an indirect transaction. Why do we need to go to the minister? But the guidelines, have been, guidelines are here to stay, and this consent requirement is one that must necessarily be complied with when you're looking at a divestment or an acquisition in the oil and gas space. So with certain transactions, and this is important because there are certain transactions that, depending on how it's structured, especially where it is structured outside of Nigeria jurisdictionally, there's usually the question of, is the obligation to get the consent triggered or not? What usually happens to play on the safe side would be to engage the DPR and get a no objection to such a transaction, to be certain that you're not running foul of the consent guidelines. And in this regard, where you are conceptualizing this transaction and before you consummate it, you're expected to notify the DPR of this proposed transaction. And in notifying the DPR, you are expected to explain the reason for the proposed assignment, the method of this, and the possible technical and economic value with the assignment that you are contemplating. Now, in the Petroleum Act is very clear that where you're seeking the governor's consent, the conditions that the minister, sorry, not the governor's consent, the minister's consent, the conditions that underpin the grant of the consent would include that this new entity that is coming to step into the shoes of the entity that holds the OML, for the sake of this discussion, is one of that has good reputation, and it has sufficient technical knowledge and experience and enough financial muscle to actually carry on the transaction, carry on the operations of the business, and in all respects must remain acceptable to the federal government. Now, whilst we would say that, I think it was a couple of years back, maybe more than a couple of years back, getting the minister's consent used to be extremely protracted. And that was something that used to impact the overall timeline and schedule for concluding a transaction, because you could basically have everything in place and you could be waiting for the governor's consent for 2 years. That is one of the issues, that, you see in transactions of this nature, where you have this third-party consents that necessarily need to be gotten before you can conclude a transaction. There's also the issue of the increased transaction cost, the overall transaction costs, because we all know how our regulators can be, and the fact that for every transaction we are doing, you're expected to pay certain fees, and that in itself could, just bloat the transaction cost. So when structuring your transaction, you necessarily must pay attention to these particular considerations and pre-agree the consequences and durations of, not getting the consent when you ought to get it, and what these delays could actually portend for the transaction as a whole. Now, in relation to acquisitions that touch on assets in the downstream, the guidelines and procedures for obtaining DPR approval for transfer of licenses, rights, or interest in downstream sector 2020 provides that any downstream operator or licensee that intends to engage in a takeover, a merger, or acquisition that may result in the transfer of a license must first notify the DPR, apply to the DPR for an approval of the transfer, pay applicable fees, submit the requisite documents specific to the relevant facility, and comply with the process specified by DPR for transfer of the licenses. So you would see from my slide that certain keywords have been highlighted: takeover, merger, acquisition, transfer of license. So you have to be very clear in your mind, especially when you're structuring the deal, even if it's a share deal, how this could sit with the relevant guidelines that impacts the particular assets that is sought to be disposed of. And like I rightly stated, transfer of license is one of the key points that I had highlighted. And it means the change in ownership or control of a license to operate the downstream facility or any interest or right through merger, acquisition, takeover, liens, mortgages, share divestment, or similar transactions. So clearly, you may be structuring the deal as a share deal. And then you're thinking, no, but really and truly, the license to a pipeline is just one of the different assets that this company holds. Why do I need to go and get the consent of the DPR? But you can see that the definition in the guidelines has expanded the transfer of license to include a share divestment, even though the license is just one of many assets sitting under that company. It also has expanded the definition of downstream facilities. So you have to pay attention to the assets held by the company in question and the assets, if it's an asset deal, the asset that you're seeking to sell or divest interest in, to determine whether the obligation to get this DPR's approval has been triggered. Now, the FCCPC approval is one that is very important. Prior to the Act coming into force, most acquisitions in the oil and gas space, basically the major approvals you needed to get was from the DPR and the minister, depending on what is being sold. But now there's an added leg to the approvals that must be gotten, and this is by virtue of the FCCPA, and it's very clear that ordinarily you'll be thinking, but acquisitions differ from mergers, and that's correct. But the provisions in the FCCPA has expanded the traditional definition of mergers to include acquisitions, such that where one or more undertakings has expanded the definition of merger and has departed from your traditional definition of a merger to state that the FCCPC, that's the commission in charge of that's in charge of the competition and competition space would deem any transaction to be a merger if it is one where one or more undertakings are directly or indirectly acquired by another undertaking. So the use of the word acquire, directly or indirectly, immediately, triggers that. But more importantly, there's the B portion of, I believe it's section 92 of the FCCPA, that says that a merger will be deemed to be contemplated where there's the purchase or the lease of shares or any interest or assets of the other undertaking. So ordinarily, if there had been no mention of the word shares, for instance, certain share deals would have, escaped this regulatory oversight. But because that is in the legislation, necessarily you must pay attention to this and determine from the get-go whether your transaction is one that has all of the characteristics of the transactions that should actually get the FCCPC approval. Importantly, there is a threshold for determining the mergers that should come to the FCCPC. Small mergers ordinarily should not come to the FCCPC, but there are certain thresholds to determine whether it's a small merger or it's a big merger. And one of the key considerations would be in the financial year preceding this transaction, the combined annual turnover of the acquiring entity and the target entity exceeding 1 billion, or is the turnover of the target entity, that's the sell side now, one that exceeds 500 million naira. So you have to look at some of these considerations in determining whether indeed the approval, the obligation to get the approval from the FCCPC has been triggered. So I think this basically covers on a broad level, what you typically would see in an acquisition deal. So just a quick recap. Very clear in your mind that you need to understand the assets that is sought to be sold. And that would help you in determining how you structure it, how best to structure it, whether it's going to be by way of a share sale or it's going to be an asset deal. You cannot forget to ensure that the relevant NDAs, non-disclosure agreements and confidentiality agreements are in place. You must ensure that due diligence is done. And in doing due diligence, you must get the right parties in the space to do the audit of the assets and or the company involved. Then you should be very mindful of the critical clauses within the key and principal agreements that you'll find, which will be your share sale and purchase agreement or your asset purchase agreement. You should also pay attention to setting key considerations like the regulatory approvals that should be in place, as well as the conditions precedents that necessarily must also be satisfied or waived by the relevant parties to be able to close the deal and close it on time. Do I have a time check? How much time do I have left? Okay. So moving on really quickly. Asset development. No. So now, after you've acquired the asset, you'll be expected to develop these assets. And there are different things that you necessarily must be aware of in developing an asset or undertaking a project. And there are certain projects that you can conceptualize from, get-go, the greenfield projects that haven't been done by anyone, or it is not in relation to an existing operation. There are different projects that could actually happen after you have acquired a particular company's shares or acquired the relevant assets. So asset development is basically what would happen post-acquisition. How do you now then work the fields, or how do you operate the facilities that you've now acquired? If they are moribund facilities, are you going to basically, scrap them, or are you going to find ways to rehabilitate them, or are you going to add on new assets and basically develop the asset for the purposes of revenue generation for the company? And so examples of asset development would include the construction of a refinery, development of a natural gas plant, construction of pipelines. So take, for instance, you acquired an upstream company. It's been in operation for 10 years. It was predominantly an oil field. Now they've discovered gas. You necessarily need to find ways to monetize the gas. So you are going to be expected to get certain facilities in place, which could include a gas pipeline. So that's you developing the asset. There's also development of marginal field or the OML acreage for the production of crude and the drilling of oil wells. Now, when you're developing an asset, and some of this permits and licenses that I have detailed on this particular slide are what you ordinarily would be expected to even look at when you're acquiring the assets. These are some of the permits that you would want to confirm are in place for a company that has been in existence and has been operating within the sector. Now, with most oil and gas operations, you are expected to be building or constructing one thing or the other. Either upstream, you're constructing facilities that would basically move the crude from where it's been, where drilling has happened, to where it's going to be processed or refined, and then ultimately to where it's going to be sold. And there are different facilities that would be constructed. And one key contract that is important to note would be the engineering, procurement, and construction contract. There are certain contracts that would be said to be engineering, procurement, construction, and installation, but the provisions are similar, but you need to understand where each contract will sit. And this basically would, this is the agreement or contract that would regulate the relationship between the project company and the contractors on the other hand. FIDIC contracts are usually adopted because they've been standardized, and the provisions are clear and known to both the owner, which would be the project company in this instance, and the contractor on the other hand. But there are specific technical provisions in this contract that you must be familiar with to be able to draft appropriately, review, and or negotiate on behalf of your client. The scope of work is one that the technical guys typically will put together, but you would not be that lawyer that would say, okay, I'm just interested in only the legal part of the contract and not be familiar with the technical, because everything is linked. You need to appreciate the entirety of the scope of work to be able to identify where certain things have not been met on time and according to specifications. So typically, where it's a turnkey arrangement, and turnkey basically just means that the owner of a project comes to you, a contractor, and says, let me make it as simplistic as possible. You are looking to build a house. So you would find a developer that is going to use, so you as the owner, you have this plot of land and you want to develop this land. You find someone that has told you or has shown you he has the experience and expertise in building houses. So you would say, okay, this is my land. I've handed the land over to you. Build this house. I need to move into the house 6 months from today. So in a turnkey arrangement, what this basically means in essence is you're not interested in the subcontractors that this main contractor is going to use. You're not interested in who is bringing the key, the door, or who is supplying the rods or bringing the cement. And all. That's not your business. All you want is a finished product. You just want to be able to come in and turn the key and enter your house. So turnkey is basically completed project. All I'm doing is bringing my body into the project and turning the key to walk into the space or the facility that has been constructed. And usually you will get one main contractor that will have responsibility for everything, the engineering, the design, the commissioning, the testing, everything. And then he will hand over that project to you once it's completed. Usually there is what you would call the front end engineering and design, which is like a preliminary phase that must be undertaken by the technical guys to determine the scope and the parameter for the project in question. And it is that feed that will determine also the commercial, to a large extent, the commercial considerations that must be paid attention to, and also the schedule for actually delivering that project. And after that feed has been concluded and design has been agreed, you would now then go into what you call the detailed design phase, which is basically you now then going into, minute details of scheduling. You're scheduling up to days as opposed to just looking at it on a broad spectrum of years or months. You're going into those specifics. You're going into specifics as to, the amounts that will be required for each, nail or each equipment that needs to be brought on board and things around that. Those are things that you typically would see in a document that is attached to what we call the terms and conditions of an EPC contract. So that your scope of work would most likely be your Appendix A. And that details all the technical things that the contractor must comply with, including the specifications and things around safety and health. All of those would be, embodied in the scope of work. Your EPC contract must also have a fixed completion date. So schedule is very important. If you're not very clear and specific as to when the project should be handed over to you, a project that ordinarily should take 6 months could drag for 2 years, and that in itself could impact your cash flow as a business. So a fixed completion date is one that must be agreed, and where the contractor fails to comply with your completion date, there are liquidated damages that would apply for failure to meet that completion date. And no contractor wants to be hit with LDs because they're trying to make the most out of the money they're being paid for the project. Force majeure provisions, we all know that due to no fault of either the owner of the project or the contractor, certain things could happen that could stall the completion of a project. Force majeure provisions are provisions that are very, very, these are key provisions that you must pay extra attention to when negotiating an EPC contract, because there are ways in drafting some of these provisions that could allow or permit the contractor to get more money off you, and everything could be deemed to be a force majeure, and that would give them the cover to, one, not meet your completion date, or two, to not comply with certain specifications or we're not able to do this because they were rioting at the ports. When you drill down, what ports are you talking about? Or some ports that is near the port where the equipment is coming from. That should not have impacted your ability to deliver the project. So there's some of those fine details when you're negotiating an EPC that you must be very on top of in order to assure that the contractor is not getting one over the owner if you're the lawyer for the owner. And of course, if you're the lawyer for the contractor, there are certain tricks as well that you could put in drafting the clauses to ensure maximum benefit comes to your client. Okay, so there are caps on liability, and this basically, this is also tied to a contractor ensuring that its profit is not eroded by certain breaches that it may have, incurred whilst getting the work done. So usually you would see provisions in an EPC contract where the contractor is seeking to cap its liability to a certain percentage of the contract price. And usually, I think the market, this cap is usually not more than 20% of the entire contract price. And as the lawyer on the owner's side, you have to be very clear in your mind that when you are agreeing the cap, it is one that if you now had to terminate the contract and get another contractor to finish what this recalcitrant contractor has failed to complete, that you are not, you're not getting more hole in your pocket in trying to negotiate or agree the cap on liability. So you will push for as much as possible for the contractor to be on the hook where it fails to comply with the key terms of the contract. Performance guarantee is one that touches on the, now for every facility and for everything that is being constructed, and that's why you have the scope of work with technical specifications. Whatever it is that has been constructed or that is being installed must be fit for purpose. So you are going to be guaranteeing that when you complete this deal or you complete this facility, it will do what it's supposed to do. That's what the performance guarantee is, basically. So there's usually the minimum performance guarantee, and then there is the performance guarantee itself. So there's the very minimum that this facility must be able to do. And then there's also, aside from the minimum, there is a higher threshold of, yes, we understand that every facility can get to this minimum, but we are trying to beat this technology. We're trying to, produce faster or do something better. So the performance guarantee will be one that will be higher than the minimum that is in the market. Usually where the contractor fails to meet the performance guarantee, but has met the minimum performance standards, the reasonable expectation is that he can cure that breach by paying certain liquidated damages, because it's not like the facility is useless altogether. It's basically one that has not met the higher threshold. But where the facility that has been constructed is one that cannot even meet the minimum performance standard, then usually the owner of the project takes the call to terminate and will hit the contractor for major termination damages. There's also defect liability period. Usually when you have constructed and or installed an equipment or a facility, you must go through the process called testing, and you're testing to confirm, one, that this facility works, it meets the minimum performance standards, and or it's able to get to the performance guarantee that the contractor has undertaken to stand behind. Now, with every equipment, there are certain things or defects that you cannot see with the naked eye. Of course, for the ones that you can see with the naked eye, you can immediately ask the contractor to either fix or replace. There are certain defects that you would only see after the facility has been tested, or more importantly, a couple of years after the facility has been in operations. So you have to be very mindful of the length of time that you are going to be putting in the contract as the lawyer for the owner as to how long this contractor will remain on the hook to make good any defects in his work. And so that is, you know, how you would be looking at structuring your defect liability period. That in simple English just means, how long am I able to hold this man? He may have completed the work in April, but I know that I may not be able to identify the defects until sometime in December. Do I extend my defect liability period to just end at December, or would I want to extend it to maybe December of 2022? Because certain defects will still not be visible by January of next year. So there are all of these considerations or things that you must be, you know, very mindful of and on top of, in able to best structure what you would be putting as the defects liability period, where you can call the contractor back to come and make good or cure a defect in his work. The contract price under EPCs are usually fixed, but most contractors will try and have a variable portion in the contract price, because they are setting variations or change orders that could affect or impact the price that they quoted for you at the point where they were bidding for the work. And then, of course, they're setting exclusions like, oh, if there's a change in law that requires me to pay more duties, for instance, on the equipment that I'm bringing in, I should be able to have a right to come back to you with a change order asking that my price be increased. So, but more often than not, as a lawyer for the owner, it is advisable for you to ensure that your price is fixed, and that the variable components are such that are very little, and they would not be one that would just be easily triggered. There should be hurdles over, you know, before you can actually change the price, because that also helps you to limit your exposure and you know, reduce your cost overruns for the relevant project. Of course, with every contractor, they can tell you they can do everything and anything under the sun, but it's only when the work actually starts that you know whether there's what they have represented is something that they can actually do. And to secure the performance of the work, usually contractors will be required to provide a parent company guarantee, so that if, for instance, the entity is one that is in Nigeria, but its parent company is one that is an international company, probably sitting in Houston, and you know that the parent company has more clout or ability to fix or do the work, you must get the company parent company guarantee to backstop the performance of the obligations of this contractor. They are also setting financial or commercial obligations that the contractor would have and would owe to the owner, where, for instance, there's a LD that has crystallized. You don't want to start chasing this contractor and going to court and, you know, being dragged for years on a claim when you could easily just draw down on a bank guarantee that has been provided by the contractor as security for its obligations under the contract. Most facilities in the oil and gas sector, they have their proprietary technicalness, if there's a word like that, with every facility. So you've got, how would I, trying to find the right word now. So take, for instance, an LNG plant, for instance. The technology for liquefying the gas is one that is typically proprietary to the owner of the technology. And it could be the contractor, or it could be a third party that is ready to provide a license for the use of its technology. Now, what you don't want as the owner of a facility that's being built is that after you have now then started running the facility, someone comes with a claim to say that the technology being used in your plant is one that they have title to, and that the contractor or the technology provider does not have title to. So one key provision is the contractor undertaking or representing that it has title to the intellectual property, to that technology that will be used in that liquefaction plant. And also giving an undertaking that if for any reason there's any adverse claim from any third party in relation to that intellectual property, they would make the owner good. Another key agreement that you would see in asset development would be the operation and maintenance agreement. So after you have engineered and constructed a facility or a plant, and most plants are expected their shelf life should be about 20 years. You know that you necessarily need to have a way to continue to maintain those plants to ensure that they are working at their maximum. So you would have to enter into an operation and maintenance agreement with another party altogether, not necessarily the contractor that constructed, and giving them the right to assist you in maintaining, operating, and repairing the facility if at any point in time there's any part of the facility that gets defective or stops working. Touched on force majeure provisions. Of course, most contracts must have a contract period. Insurance is something that's very important. At the point where you have constructed a facility and where the shelf life is 20 years, like I've said, anything can happen in year 2 or year 5 or year 10. There could be a fire outbreak and you could lose all of that investment. But then if you've taken the steps to insure the premises or the assets, then necessarily you should be able to recover your monies from the insurance if any of the ills that you've insured against come to pass. Assignment and subcontracting. Usually with this, where the entity that is sought to be brought on board as the subcontractor or the assignee is one that is a subsidiary of the main contractor. Usually what is required would be just a notification to the owner that, okay, we're going to be assigning this part of our obligations to this entity. But whereas a third party altogether that is unrelated to the contractor in question, the typical provisions you would see would be that the consent of the owner must be procured and the reason for that is the owner wants to be certain that whoever it is you're assigning or subcontracting to is one that can meet the obligations that you have undertaken to do. Product supply and offtake agreements is basically you have acquired this asset, it's upstream, you started producing, necessarily you must find off-takers to buy what you have produced, either it's crude or it's gas, and necessarily your counterparty, the off-taker, must be one that is credit worthy. On the other hand, the off-taker must be confirming that the product that you're saying that you have to sell is one of good quality and you have the quantity that it requires. So you'd have provisions in there that deal with maximum and daily quantities that the party supplying must meet. There are provisions in there to deal with, if we've agreed that this is the specification of the crude or the gas that we're buying from you, if there's going to be, for any reason, this product's going off spec, there are provisions that would be put in the relevant agreement, in the offtake agreement, to assure the offtaker on how to deal with that, especially because you do not want an off-spec product to damage your facility one way or the other. Of course, there are pricing mechanisms for contracts of this nature. Invoicing is quite key. You need to be clear in your mind, because that also helps cash flow for the seller of the product, of how long would it take from when I submit the invoice to the off-taker for me to get paid for the product that has been supplied. Of course, there'll be penalty for late payment. Risk and property. Well, this is a point that I should have touched on during my the conversation around the engineering, procurement, and construction contracts. Now, procurement, a key component of the EPC contract is you having the obligation to procure certain key equipment for the facility that is being constructed. And at the point where you're procuring this equipment, more often than not, this equipment will be shipped from one jurisdiction to the other. The question is, if it's a turnkey arrangement, where would the risk of loss sit when, for instance, maybe the ship sinks on the high sea? Now, remember, it's turnkey. Price has been agreed. Owner has said, this is what I want to do. You are going to buy everything and couple everything together. And then the contractor comes to you and says, yeah, we bought the equipment like we undertook to, but right now we do not have the equipment anymore because the ship that was transporting it has now, is at the bottom of the sea. What usually will be best, if you are the lawyer of the owner, would be for you to separate the risk of loss from the title. Now, everyone knows, well, I guess is law 101, that risk of loss usually, is linked to the title to the asset. So if you're the owner of the asset and something happens to that asset while it's being transported, then you are the one that has lost it. But because of the very nature and peculiarity of EPC contracts, usually, while title to the asset should pass to the owner once the owner has paid for that equipment, even before the equipment has actually been transported and has landed the project site. You can divorce the title that will sit with the owner once he has paid from the risk that is attached to the loss that could come out of that equipment getting damaged or the ship sinking. And that could rest with the contractor. So that, basically just keeps the contractor on the hook to ensure that you're not, being cheap by getting a very unworthy ship to, load the equipment on. So you have to do your due diligence on the kind of carrier that would be bringing this equipment in and take all the steps to assure that even if nothing happens while it's being transported, when it is being offloaded on the site, that no damage happens to it or no theft or nothing happens to it, because you would remain on the hook on it for that until such time that you have now then coupled this procured equipment together and handed over the facility to the owner. Payment of tax, you can't run away from that. Government is always looking for ways to generate revenue, so you must pay tax. And then termination provisions. There are different things that underpin termination provisions. And one important mechanism that should be noted is that you could actually structure into your agreements whether it is an EPC contract or an offtake contract, what should happen where termination occurs and where the termination is occurring as a result of no fault of yours. So they're setting termination payments that could be made if termination has occurred because somebody just decides after undertaking to be bound to you for maybe 20 years. So just say, well, you've not been in breach, but I just don't want to proceed with the deal anymore. You're expected to, get this counterparty to be on the hook for such early termination. And there are different mechanisms around structuring the termination provisions. So it's 4 o'clock. And the rest of my presentation actually deals with financing, acquisitions, and developments, but I understand that this class has already been taken and we're already at 4 o'clock. So I think at this point, I'm just going to open up the space for questions. Thank you.
Thank you very much, Stella. Good afternoon, everybody. There are a couple of questions in the Q&A box, and if you're ready, I'll take them right away. Okay, the first question here says, what legislation should be kept in mind when representing a government entity during acquisition?
Okay, thank you for this question. I'm not sure if the participant that asked this question was here when I touched on this. But one key legislation that you necessarily would need to pay attention to will be the Public Procurement Act, because that's the legislation that deals with divestments of government agencies. And more importantly, it also deals with the procurement process that must be followed where you're seeking to acquire, if you're a government entity and you're seeking to acquire assets. And this is because they're very key provisions or regulations that touch on specifics around bidding, how you should bid, and to ensure that it's a competitive bid and one that complies with certain key procurement rules. So the Public Procurement Act is one key provision that you must understand the very specific provisions around if you are acting for a government entity during an acquisition. Because you have, even in that legislation, there's a definition for what will be deemed to be divestments, and there are quite detailed provisions on how the bidding process should be done.
All right, thank you very much. There's another question, and it says, is it possible to acquire an economic interest in an asset as opposed to a participating interest? If yes, what ways can this be structured? And have you ever handled such an acquisition? Should I take the question again?
No, I can actually see the question. Yes, I actually have. I think it's Onyinye that asked the question. I've actually participated in an acquisition transaction that basically had to do with acquiring the economic interest as opposed to the participating interest. And the reason, this is one of the structuring mechanisms that could be deployed when you're trying to ensure that certain triggers that could impact your transaction do not crystallize. And let me give an example. Participatory interest, and maybe we can use the example of a share sale deal. So there are certain transactions that, depending on the quantum of shares that you're seeking to acquire, if it gets to 51%, it could trigger the requirement to get certain approvals and certain consents. Depending on how fast or quick the transaction needs to be closed, and if you recall, I touched on the fact of getting certain consents could unnecessarily delay and protract a transaction. So where it's a time-sensitive transaction and one where you know that going the whole hog of getting the consent could impact the ability to close the deal, you could structure it in such a way that whilst you would be acquiring shares that do not get to that threshold on the face of it. So the number of shares that you're acquiring would not be 51%, but the economic interest attaching to the shares that you're acquiring would actually be 100%. So it's in the language and in the how you have structured the agreement that it will now then be clear what it is that you're buying and how this will, be structured in the documentation. I don't know if I'm clear, but basically you could structure it in such a way that on the face of the documents and in the share register, for instance, Stella Duru is saying to be holding 49% of ABC Limited. But in actual fact, the 49% is only going to be seen against my name in the register of members and at the CAC. So I will become the holder of 49%. But the 49% behind it, I'm entitled to 100% of the dividends that, that would be payable for all of the shares in that entity, save maybe one share. Before CAMA 2020 came into force, you needed like 2 shareholders at any point in time. Now you can have 1 shareholder. So in that case, in the respect of before CAMA 2020, you would basically be entitled to dividends on 100% or 99%, 99.9% of the shares, but you would only be seen to be holding 49%. So there are ways to structure all of this, and all of this would be preserved and recorded in your share purchase and share sale and purchase agreement.
Okay, thank you very much. There's another question, says, what are the remedies available to a technical partner under an OML contract wherein the technical partner met the minimum standard, but due to acts beyond the control of the technical partner, they could not meet up with completion, re-entering the well, and they were denied contingency claims, despite the vendor terminating the contract before the stipulated time?
First and foremost, I don't know that there's anything called an OML contract. But to just answer the question, if you've got provisions, met the minimum standard, but due to act beyond the control of technical partner, they could not meet up with the completion, re-entering the well, and they would deny contingency claims. Now, this particular circumstance would necessarily need to be investigated, because when you say the acts beyond the control of the technical partner, are we speaking to force majeure events? Are these events that would fall under your definition of force majeure under the relevant technical services agreement, such that you are excused from meeting your obligations because certain things outside your control have not, impacted your ability to meet your obligations? But if these are just things that are within your control, but you are seeing it as acts beyond your control, but they do not fall under the definition of force majeure in the contract you have actually executed with the OML holder, then you really and truly cannot be claiming any contingency claims. Which is why I kept repeating that, the drafting and the reviewing of clauses of key contracts are very important. We're lawyers, and every word in a document is important. So you need to be, as the advisor, if you're the advisor to the technical partner, you need to be very clear as to what the agreement said and what the rights of your client is under those agreements. Because if there are really acts that you say are beyond the control and they fall under the definition of force majeure, which is why sometimes you must ensure that you define your force majeure. You define force majeure to be very expansive, because you try as much as possible to anticipate the issues that could impact your ability to meet your obligations and see if it's something you can bring under the umbrella of force majeure, such that you are excused for meeting that and not be held as being in breach for something that is outside of your control.
All right. There's another question, and there's a hand that's raised. I think we should take that. Olushina Odogua. I'm sorry, if you can hear me, you can kindly unmute yourself. I don't know if he has a question or a comment. Olushina. Okay. So that's good. There's one more question. Is it typical to ask for collaterals or other forms of security when a party seeks to invest in a company via the acquisition of shares?
Okay, so the word invest has been put, in inverted commas. So the investment here, if you're acquiring the shares straight up and you're not extending a financing to an entity that is acquiring the shares, then I'm struggling to understand the ask for collateral. You typically will ask for collaterals or forms of security when you have extended a loan, if you're a lender in a situation and not the holder of the shares that would be acquired. Now, if you are a lender that has extended money for the acquisition of shares, you typically would, now I don't know how this would apply. There's a deed of share charge that would cover the shares for which the financing has been extended, and basically creating a lien over those shares such that the holder of the shares cannot sell those shares. And then the ability to be repaid from the dividends that attach to those shares would now then, not be available to the lenders. But if you are going to be a shareholder holding the shares in your name, there's no collateral. You are basically a shareholder. The shares will be your name. You have the title to the shares. You bought the shares. But if you have a third-party financier that has extended the shares to the owner or extended monies to you to acquire those shares, then that third-party financier would create security over those shares that you hold by creating a deed of share charge over those shares so that you can't sell them, like I said already.
Okay. That seems to be the last question on the Q&A chat box.
You said you had someone that had raised a hand?
Yes. Olushina Odogua his hand is raised here, and I can see he's been permitted to talk. No response. Okay. So, in the absence of any other question, I will just no.
I actually have no question. Thank you.
You have no question, or you have a question, sir?
I have no questions. I have passed my comments.
Oh,
the
okay.
lecture is quite insightful. Thank you so much.
Thank you very much, Olushina.
You're welcome.
Okay. Thank you very much, Ms. Stella, for such an insightful session today. Thank you for really breaking it down. We're so grateful to you. Thank you for your time. And so many participants are asking for the slides, and I've told them that slides will be made available to them at the end of the training session as well. So yeah, thank you very much. And any closing words from you?
No, thank you very much. And again, thank you to everyone that's joined. And for the questions that were asked, thank you very much to everyone. And I confirm that I will make the slides available to the faculty, and that will be shared with participants that have joined. Thank you, and do have a good afternoon, everyone. Stay safe.
Thank you very much.